Have you ever had problems with clarity issues in foreign countries, yet the same exact claims had no problem whatsoever when in the US? Well, today we're going to be discussing the differences between definiteness under US law and clarity in foreign countries. Hi, I'm George Meyer. I'm a patent attorney and have learned much during my patent journey of about 30 years. With these weekly videos, I will share tidbits that I've learned along the way to help you with your patent practice. Subscribe to this channel so you don't miss any of my weekly videos. Now let's turn to this week's topic.
This week's topic is Let's Be Clear. And with this, we're comparing definiteness under 35 USC 112B as compared to clarity as used outside the US. What you'll discover is that definiteness under 35 USC 112B has significantly changed with Nautilus. Clarity in foreign countries still remains a stricter standard than definiteness in the US. Now, before Nautilus, claims were rarely invalidated at the Federal Circuit for being indefinite under 35 USC 112B, or in the older days, Section 112, Paragraph 2. Many litigators favored ambiguous language because there was not too much of a problem with definiteness. So we were instructed when I first started to be as ambiguous as possible to allow litigators the greatest amount of flexibility depending on what happened in a case many, many years later. Claims are usually giving a saving interpretation as to not be invalid. Now, Nautilus changed things with respect to the definiteness standard. After reading the specification, the claim scope needs to be reasonably certain to a person of ordinary skill in the art. Now, one area that's problematic are test methods. Where or when are readings taken or determined? Keep in mind that test methods must be specific and complete. Now, you can have a wide range on the parameter which would be the outcome of the test, but the test methodology itself must be complete and specific. You can't omit details. And just listing a testing standard may not be enough. Many of us may rely on ASTM, NIST, or Underwriter Lab standards. But many of these standards have more than one test within the standard. Beyond that, there could be a new version or change to the standard. So if you're going to give a standard, you better give a revision number or a date of release or other date related to the test. Now, there may be more than one test methodology that can be used for determining parameters such as density, porosity, or another variable. Well, under U.S. law, the relevant indefinite inquiry becomes whether the different methodologies lead to materially different results in defining the boundaries of the claim. So you can have more than one test standard, but if the difference in the parameter is minuscule, the claim is probably not going to be invalidated as being indefinite. If there are material differences with the parameter, then it could potentially be indefinite. Let's now move to clarity. This is the standard used outside the US. Now, the claim language needs to be clear on its face, not subject to reasonable debate. With that example I just gave with the two different methodologies, that's a problem. Notice we're not even discussing whether or not the parameter differences are going to be significant or not. There is ambiguity. As soon as you have ambiguity, you got a problem outside the US. Automatically, the claim is going to be rejected or it's going to be invalidated if it's after grant. Unlike the US, there is no saving interpretation. We have a problem with terms like about and approximately. In most countries, they don't want to see it at all. You will usually not be able to get claims with about or approximately allowed unless you assign a numerical value to what you mean by about or approximately. So what are the takeaways? Well, first, U.S. law on definiteness is getting closer to clarity. But clarity is still a tougher standard, especially in Asia, where claims are read more literally and almost to the point of being hyper-literal. Ambiguity usually means an automatic rejection or invalidation, and you're not going to get a saving interpretation. So when you're drafting claims to comply to the stricter clarity standard, you should be okay in the US and you should be foreign. And many of us who had been drafting to the clarity standard before Nautilus didn't even have to change our practice in order to comply with the change of Nautilus because we were using the stricter clarity standard. So with that, we are done with this video, and we hope that you liked it. And if you like this video, give us a like and leave a comment. Remember to subscribe to this YouTube channel, or better yet, sign up for our email list at georgermeyer.com and get a freebie. Currently, the freebie is my dependent claim equation. Many practitioners told me that they wish they had the equation earlier in their careers. It's that good. Follow us on LinkedIn. Thank you for your time, and check next week for a new video. See you next week.